Welcome back to Legal English. In today's intermediate class, we're shifting from theory to practice. We're going to talk about client intake interviews. This kind of interview is the first step in many legal cases. It's where lawyers gather important background information, ask the right questions, and begin building a relationship with the client. So, in this lesson, we'll learn how to ask about facts, ask about the client's background, and use language that builds trust and confidentiality. Let's get started with some practical legal speaking skills. So, here's what you'll learn in today's lesson. We'll start by looking at the structure and goals of a typical client intake interview, how lawyers use these meetings to collect facts and assess cases. You'll learn and practice useful terms like intake, background, facts, and confidentiality, vocabulary that's essential in early client conversations. Then we'll focus on how to ask good questions, when to use open-ended questions to get stories, and closed questions to confirm details. Finally, we'll work on using sequencing language like first, then, and finally, and polite grammar forms to sound clear and professional throughout the interview. Let's start with a warm-up. Imagine you're meeting a client for the very first time. These are the kinds of questions lawyers typically ask to begin the intake process. You might start with, "Can you tell me a bit about your background?" This opens the door for personal and legal context. Then you might ask, "What happened before the incident?" which helps you gather a timeline. "What are the main facts of the case?" This gets to the core legal issue. And it's important to ask, have you spoken to any other lawyer to check for conflicts or prior advice? Finally, you'll remind the client, everything we discussed today is confidential. Do you understand? This sets the tone, professional, clear, and respectful. Now, let's break these elements down together. Let's begin with our first word, intake. Intake is the initial process of collecting information from a new client, usually during the first meeting. For example, the paralegal handled the client intake before the attorney joined the meeting. Now, imagine this. A client walks into a law firm, visibly nervous. They sit down across from someone and begin answering questions. Name, contact details, what happened, when it happened. This first conversation is intake. It may seem simple, but it's crucial. Intake is where the legal process starts. It's how you gather the story, identify the facts, and begin building trust. Done well, intake sets the tone for the entire case. Done poorly, it leads to confusion and missed details later. Next up is background. Background is a client's personal history or context, especially the parts relevant to their legal issue. For example, before we discuss the case, I need to understand your background. Now, let's picture a client meeting. A woman is upset about being dismissed from work. Before diving into legal rules or documents, the lawyer asks, "Can you tell me a little about your background?" That includes how long she worked there, her role, her experience, maybe even previous complaints. Why does this matter? It's because the background helps the lawyer understand not just the incident, but the full context behind it. In legal English, learning someone's background isn't just polite, it's strategic. Facts. Let's look at facts. Facts are objective details about what happened, including time, place, actions, and people involved. For example, we could say, let's focus on the facts. What happened? When did it happen? And who was involved? During an intake interview, emotions can run high. A client may say, "My boss is unfair. He's always targeting me." But a lawyer needs specifics. So they ask, let's focus on the facts. What happened? When did it happen? And who was involved? Facts are the building blocks of every legal case. They're the difference between a story and a strategy. And helping clients move from opinion to fact is one of the key skills of intake. Confidentiality. Now let's talk about confidentiality. It is the legal obligation to keep client information private and not disclose it to others. For example, you can always hear, everything you tell me is protected by confidentiality. Picture a client who hesitates before speaking. Maybe they're about to share something personal, a problem at home, a secret from work. This is where the lawyer says, everything you tell me is protected by confidentiality. And that moment changes everything. Confidentiality means the client can speak freely, knowing their words won't be repeated. It's not just good manners, it's a legal duty. And for many clients, it's the reason they feel safe telling the truth. Next, we have clarify. Clarify means to make something clearer or easier to understand, especially when a client's answer is vague or confusing. For example, you could say, I just want to clarify, did this happen before or after the phone call? Let's say a client is explaining what happened, but the timeline is not clear. They're jumping from one event to another, emotions are high, and you don't know the order that things happened. That's when the lawyer steps in gently and says, I just want to clarify, did this happen before or after the phone call? Clarifying is not interrupting, it's guiding. It helps keep the story straight and ensures you're building a legal case on solid ground. And finally, we have timeline. Timeline is a sequence of events in the order they occurred, often used to understand a legal situation clearly. For example, can you help me build a timeline of what happened from start to finish? Sometimes a client gives you the pieces of the puzzle, but not in order. One event happened in June, another in April, then something a few weeks ago. So that's when you can say as a lawyer, let's build a timeline, putting events in order from start to finish. This can reveal patterns, gaps, or key evidence. A clear timeline is often the lawyer's first tool to spot what really happened and when the law may have been broken. Now, let's test your vocabulary with a quick challenge. What's the legal term for the first meeting where a lawyer collects a client's basic information? Let's look at it through a story. Picture a small law office. A woman walks in, nervous, confused. A paralegal sits her down, offers her a form, and gently asks her about her situation. It's not time to give her legal advice. This is the moment to gather facts, ask background questions, and see if the case can move forward. That first meeting is called the intake, and it's how every case begins. Here's another one for you. What's the legal term for the rule that client information must be kept private? Let's imagine another story. A client walking in with a sensitive problem that involves his family, finances, or maybe even a personal mistake. They lower their voice and say, "Can I speak freely?" And that's when you say yes. Everything you say is protected by confidentiality. And just like that, it helps the walls to come down. Confidentiality is what builds trust in legal relationships. It's not just a courtesy. It's like we said before, it's a legal requirement. Let's do another one. What's the legal tool used to organize events in the order they happen? So let's say you have that client that tells you the end of the story first, then jumps to the beginning, then jumps back to the end, and then goes to the middle. Different pieces from different months. To make sense of it all, you can say to the client, let's build a timeline. A timeline is like a legal roadmap. It lets the lawyer see what happened, when it happened, and how the pieces connect. It's one of the most powerful tools in early case analysis. Now, let's talk about one of the most important tools in any client interview: questions. There are two types we rely on most: yes no questions and open ended questions. Here's the difference: a yes no question simply gives you an answer of yes or no. It's useful when you want to confirm a detail. For example, did the incident happen at work? Yes or no. That's all you need. But if you want a full story, you can use open-ended questions. A question that begins with words like what, how, or why, or can. For example, can you describe what happened in your own words? Let me give you a real-life example. A lawyer is interviewing a client about a fall, an accident at a job site. If she only asks yes-no questions, were you injured? Did anyone see it? She gets facts but no story. So instead she says, tell me what happened, step by step. And that's when the client opens up and the real details come out. Now, let's look at how we help clients organize their story and how we keep things clear when they speak. The secret: sequencing words, small but powerful. Words like first, then, after that, finally. Here's how it works. Imagine a client saying, well, I told someone. No, wait. Before that, I got an email. Oh, and then I think human resources said something after. It's hard to follow, right? So the lawyer helps them slow down and structure the story and says, let's go step by step. What happened first? Then together they build the story. First, I filed a complaint. Then I spoke with HR. After that, I waited 2 weeks. Finally, I got a response. It's like building a timeline, but through words, and sequencing helps the lawyer follow the facts and helps the client feel heard, organized, and confident. Now, let's try a sequencing challenge. You'll see 4 things that happened, but they're in the wrong order. Here they are. I called the police. I saw the man run away. I gave a statement. I heard a loud noise. Now, pause the video and try to put the events in the right order. And as you do it, practice using sequencing words. First, then, after that, finally. So here's one way to organize it. First, I heard a loud noise. Then, I saw the man run away. After that, I called the police. Finally, I gave a statement. When you use sequencing words like these, the story becomes clear and professional, perfect for a legal interview or court summary. Now, let's work on asking better questions, the kind that helps clients tell their full story. Here are 3 simple yes-no questions. But here's your challenge. Rewrite them or say them as open-ended questions. Did you go to the hospital? Were you alone? Did you call anyone? Now take a moment and see what you can come up with. So you can pause it here. Here's what I suggest. Did you go to the hospital becomes, can you walk me through what you did after the accident? Were you alone becomes, who else was with you at the time? Did you call anyone becomes, what did you do next? Notice the shift. These questions invite a longer answer, more detail, more facts, more useful information. And in a client interview, that's exactly what you want. Now we're going to go to my favorite part, idioms. The first one, lay your cards on the table. This means to be completely honest and transparent, sharing all the important facts openly. In a legal intake, this is exactly what a lawyer wants from a client. No secrets, no half-truths. For example, during the intake interview, the client laid all her cards on the table about the incident. Being upfront helps build trust and means the lawyer can prepare the best advice. The next one, the devil is in the details. This is very useful. This means small facts or fine points, often missed at first, can create big challenges later. In legal work, missing one detail can change the whole outcome of a case. And so we could say, the lawyer reminded the client that the devil is in the details when reviewing the contract. It's a warning to pay close attention during intake and document review. Next idiom, keep it under wraps. Here's a phrase about confidentiality. It means to keep something secret or private. Lawyers use this when assuring clients their information won't be shared. So, we could say, for example, the attorney promised to keep all sensitive information under wraps. Clients need to know their stories are safe. Next one, get to the bottom of it. This one means to discover the real reason something happened. In a legal intake, a lawyer asks questions to get to the bottom of the client's issues. For example, the investigator worked hard to get to the bottom of the accident. It's about digging deeper than the surface. Next one, dot the I's and cross the T's. This is a classic idiom. It means paying close attention to every detail to make sure everything is perfect. In legal work, this is crucial, especially before signing documents or court submissions. For example, before submitting the contract, the lawyer made sure to dot the I's and cross the T's. Missing small details can lead to big problems. And in black and white. This phrase means something is written down clearly and officially, usually in a contract or document. When clients want certainty, lawyers show them what's in black and white. For example, the terms of the agreement were in black and white in the contract. It's proof that promises or rules are recorded. Now, let's wrap it up with a story about a day in the legal intake office. So, let's put it all together, everything we've learned today, into one real-world moment, from vocabulary to grammar to idioms. It's Monday morning, and a new client walks into the law office. The paralegal begins the intake process by asking, "Can you describe what happened in your own words?" An open-ended question to encourage the client to speak freely. The client starts nervously, but the paralegal gently uses sequencing words. First, tell me what happened. Then, what did you do next? This helps organize the story like building a clear timeline. As the client shares the facts, what, when, and who, the paralegal reminds them, everything you tell me is protected by confidentiality. You can feel safe to lay your cards on the table. The client relaxes and opens up more. At one point, the client's story gets a little confusing, so the paralegal asks, "I just want to clarify, did this happen before or after your meeting with HR?" This shows the power of using question forms to get the truth. The paralegal listens carefully because, as every lawyer knows, the devil is in the details. Missing small facts can change the whole case, so they dot the I's and cross the T's, making sure no important detail is left out. After the meeting, the lawyer reviews the intake notes, confident they have a clear picture, all laid out in black and white, ready to get to the bottom of the client's problem. That day, the client felt heard, safe, and understood, all because the legal team used the right vocabulary, asked the right questions, and respected confidentiality. They truly helped the client break the glass ceiling of fear and uncertainty, and that's how every great legal case starts, with a clear intake, a well-organized timeline, and a commitment to getting every detail right. Before we wrap up, let's review what we covered today. First, we learned essential vocabulary for legal intake interviews. Words like intake, background, facts, and confidentiality. These form the foundation for clear client communication. Then we practice key question forms, including yes, no, and open-ended questions, which help gather accurate and detailed information. We also focused on sequencing words first, then, after that, and finally, to help organize client stories into clear, logical timelines. You saw how clarifying questions are vital to fill gaps and make sure nothing is missed during interviews. Finally, we explored legal idioms that add color and professionalism to your language, such as lay your cards on the table and the devil is in the details. Great work today. You're strengthening your ability to communicate like a confident legal professional in English. See you in the next class.